Hello, everyone, and welcome to today's webinar, Looking Ahead, Top 10 Legal Risks and Management Solutions for Associations in 2021. I'd like to introduce our presenters, Kellie Newton of Whiteford, Taylor & Preston, and Derek Symer of AHT Insurance. Please note that this presentation has been approved for 1 hour of ASAE CAE credit. Before we get started, I'd like to go over a few items so that you know how to participate in today's event. You've joined the presentation listening with your computer speaker system by default, but if you would prefer to join over the phone, just select telephone in the audio pane and the dial-in information will be displayed. All attendees are in listen-only mode. You will have the opportunity to submit text questions to our presenters today by typing your questions into the questions pane of the control panel. You can send in your questions in at any time during the presentation. We will collect these and address them during the Q&A portion at the end of today's webinar. We will also be launching multiple polling questions throughout today's session. When the question appears on your screen, please just click onto your screen to make the selection. Today's webinar is being recorded. The information contained in this presentation is provided for general informational purposes only and is not intended to serve as legal advice. A copy of the audio recording and slide deck will be emailed to you within 48 hours of the completion of this live presentation. And I would now like to pass the presentation over to Kellie. Kellie, take it away.
Thank you, Lucy. Thank you for being with us today. I am Kellie Newton, as Lucy said, and I'm a partner at Whiteford, Taylor & Preston. I'm a member of our firm's association, nonprofit, and political organizations practice. My office is located in either Washington, D.C. or, in the time of COVID, in Bethesda, Maryland. What we would like to talk to you about today is how risk is created and how risk can be reduced. The result of unmanaged or unexpected risk could expose an association to financial loss, damage to its reputation, and loss of confidence of its employees, board of directors, members, and others. Derek and I are going to briefly identify what we see are the top 10 legal risks that associations will face in 2021. And we're going to provide you some advice as how to reduce those risks. Because of our time limitations, we will only be able to provide a very high level account of each of the 10 areas. We don't believe that any of these, even COVID at this point, except perhaps as it relates to vaccinations, are new to any of you. But as we all begin the new year, we hope that items on our list will cause each of you to examine your individual association's risk management program and consider additional ways to avoid costly mistakes. As Lucy said, we'll take questions at the end of the program. But if we don't get to your question, or if you think of something after the program ends, please don't hesitate to contact either of us by email, and we'll get back to you with our responses. Derek, over to you.
Thank you, Kellie. Hi, I'm Derek Symer, and I am a partner with AHT Insurance, a Baldwin Risk partner. I've been with AHT since 2003 and have approximately 20 years of experience in the insurance and risk management fields. I currently head AHT's not-for-profit practice, and we are one of the largest not-for-profit practices in the United States, specializing in trade and professional associations. We have particular expertise in the areas of directors and officers coverage, errors and omissions, cyber, international, and event cancellation. And I just want to thank all of you for joining us today. As Kellie said, we are going to be covering the top 10 risks that we perceive from our various practices in law and insurance. And we recognize that any top 10 list is not going to be exhaustive. So if there's anything that you think we should have added or left out, as Kellie mentioned, please add it to the chat box or email us, and we'd be happy to address your concerns after this event today. So just a quick word about the format. We're going to go through the top 10 risks. And at the top of them, I'm going to give a few words about why we think these risks belong in our top 10 list. At the same time, a poll question will pop up, which we would like you to answer. And that'll give us a sense of how serious you view the risk from your perspective as an association. And the answers are pretty simple. You can answer high, medium, or low, and we'll have some instant results to share with you. So let's get started. Risk number 1, contracts. So from a risk management perspective, contracts are always going to be important. They spell out who is going to be doing what is the scope of the contract, what are the payment terms, and as an association, how will we be made whole if something goes wrong? Well-structured contracts can really protect your interests of the association. And when we look back at 2020 and COVID, contracts were really critical in terms of how events that were canceled in 2020 played out for your association, whether you were able to get out of a contract or you had some penalties and fines, et cetera. So really reviewing those contracts up front is critically important. Kellie, if you'd like to go into the legal aspect, we can take a look at the results, and then you can talk about the legal part of this.
Okay. Lucy, do you have the medium risk? Okay, very good. Well, as Derek mentioned, there's a great deal of risk created through an association's contracts and other agreements that they may have. Sometimes there are contracts that aren't written or agreements that aren't written, which is a big mistake initially. But I will tell you that there is a great deal of claims made and litigation in the US that are due solely to poorly drafted agreements or even lack of agreements. One or both parties to contracts often become unhappy with the services provided. And for an association perspective, associations hire or retain many vendors to ask for certain services, for example, to create a website. And often contracts are not sufficiently detailed to detail exactly what services are going to be provided, what the costs are, when the deliverables should be received, if the contract is subject to termination, and among other things, who owns the end result, who owns the deliverables. And it's those items there that are often result in claims or litigations or disputes between the parties, and one party or the other ends up being very unhappy. The issues with contracts arise for many reasons. One is associations are often, and others are often would like to save costs or save time, so they think, well, let's just use this other association's contract that I brought with me, from my previous employer, or I can find something off the internet and we'll just change the names. You see this often with non-disclosure agreements, but specifically non-disclosure agreements, because they do protect your intellectual property and your proprietary information, should be drafted specifically towards your association. As I mentioned earlier, failure to adequately address services and deliverables, that's a major issue, and lack of benchmarks. One of the other issues that I see quite regularly, just had a client have an issue with this, is there's no ability to terminate the agreement, none. And sometimes if there is, it's either with or without cause. If it's with cause, there's no definition of cause, or there's no definition of breach. Often the language uses the term breach, but there's no definition, so what ensues is an argument of whether that has been triggered or not. Automatic renewals are also a huge problem. If you're going to sign an agreement with an automatic renewal, you need to have some type of planning mechanism internally to be able to trigger your desire for that not to happen. So generally, if there's an automatic renewal, one party or the other, generally in your situation would be the association, has a time period to say, hey, we don't want this to renew. I recommend generally that automatic renewals not be in an agreement with an association unless it absolutely benefits the association to have it there. One of the major issues is indemnification, hold harmless, waiver, limitation of liability clauses. These are very technical legal issues, and they really should receive at least a review from your legal counsel, at least for those provisions, if not the entire contract. Especially with indemnification, you may find later on that the association is now obligated to defend and perhaps pay damages to the vendor for something that may happen. One thing that I often see associations fail to do is they don't have a policy who dictates who can bind the association by signing the contract. That's very important. Not everybody in an association should be able to sign a contract. And lastly, just want to remind everybody that there is an IRS distinction between an independent contractor and an employee. Too often, associations and others enter into what they call an independent contractor agreement, and the services really are being performed by what the IRS would perceive as an employee. So that is a lot of risk, because if the IRS does come and audit you, they're going to ask you to pay back taxes and other things. So, Derek, over to you.
Well, thank you, Kelly. I just have a couple of observations from the insurance angle. First of all, we want to make sure that all of the contracts of an association get in front of your insurance broker as early as practicable for our review and comments. Obviously, we're not attorneys, so we're not going to weigh in on the legal aspect of the contracts, but we would like to take a look at things like your hold harmless agreement, the indemnification language, and just make sure that the insurance requirements that are being spelled out in the contract are reasonable, and that you as an association are going to be able to comply with what is in that contract from an insurance perspective. The second observation I had was really around kind of when a claim happens, and just to point out that many scenarios, for example, a cyber breach, if you're using a third-party IT vendor, for example, your cyber insurance carrier is going to ask for that contract that you have in place with that IT vendor at the time of a claim. So that contract then is going to become a really critical piece of kind of adjudicating the outcome of that claim. So just a couple of observations from my side on contracts, and I think we can move on to our second risk for 2021, which is cyber. All right, so we're going to throw up the poll question here for you, and there's really no surprises that cyber risk makes our top 10 list for 2021. I'm sure it's not a shock to you as attendees. Obviously, cyber threats only continue to increase, right? The push to the rapid working, remote working environment in 2020 created a lot of challenges for IT departments and for associations to really protect against end user vulnerabilities. At the end of the year last year, we saw the SolarWinds breach. We heard about the Russian breach into some of our governmental IT systems as well. And statistics from cyber and IT experts only point to increasing activity. And I can just say anecdotally from the insurance perspective, we've seen a really significant uptick in claims in 2020, in particular around ransomware. So those are some of the big issues that I see, and we can take a look at the poll question. Again, we're kind of coming in at medium risk, Kelly.
Interesting. I would have thought that this topic would be seen as a major risk. I think it's a major threat to associations and companies everywhere. Breaches will occur, of course, if the association doesn't anticipate the breach, which largely means establishing appropriate internal protocols, or if the association fails to invest in cybersecurity technology. Unfortunately, as Derek said, these risks are not going away. And as soon as some technology is created to keep out one harmful piece of malware, then those people who use who use the malware are going to come up with something else. So technology is always going to be needed to be updated, and you'll always need to have money in the budget to invest in that new technology. As you all know, one of the issues with cyber breaches is that the association has personal information of not only its employees, but of its members and others. And many statutes, including GDPR, I'm sure you've all heard of GDPR by at this point. Other countries such as Japan have stringent, if not more stringent, requirements, and even the US now, with Canada and other states having particular requirements with regard to individual personal information. What the association needs to do, in addition to investing in technology and having internal protocols, so they know how to quickly handle any kind of breach, is the association needs to train its employees as how to avoid malware risks. Training not only will go a long way to prevent breaches. An employee needs to be able to recognize when he or she's received an email that he or she should not open. But it will also go a long way to demonstrate that the association took appropriate steps to minimize the risk of a breach if there's ever any claim against the association. We talked about policies and procedures, not only to ward off breaches, but to lay out a plan of action. That plan should include notification to individuals whose personal information may have been compromised. Part of the risk management for cybersecurity is language and contracts with vendors. Again, getting back to our first point about contracts. A contract with any vendor that you may retain that may have access to any personal information of your members, employees, or others. Those contracts need to specifically address cybersecurity. And you want to try to shift the risk if they have a breach, and this is when they have a breach, which would have an impact on could have an impact on the association, that they are responsible for any damages that you incur, and that either could be, hiring your outside technology expert to look at what actually happened, legal fees, and other issues that you may have to deal with because one of your vendors had a breach. One of the primary considerations with vendors is you need to do your homework before you hire a vendor. Really need to kick the tires and ensure yourself that this vendor has everything in place in order to protect the data, your data that it has access to. Derek?
Well, thank you, Kelly. I just had a couple of observations from the cyber insurance angle. First, just sort of a quick reminder that cyber insurance covers both the first party and third party loss. And by that, I mean, from a first party perspective, Kelly was talking about, a breach of your members' personal information, for example, and the cost to your association of responding to that breach, to provide notification to those people that their information had been compromised. Those are examples of first party loss. There's also the cyber extortion angle and business interruption as well. On the third party side, we're talking more about the liability piece of this. So this would be network and information security liability, as well as any cost to respond to regulatory proceedings or PCI fines and PCI compliance, things of that nature. Secondarily, not to rehash this too much, but we talked about cyber claims increasing, and statistics are certainly pointing to that. So we're starting to see some pretty hefty increases in the cyber insurance market as the insurance carriers are dealing with a fairly large influx of claim activity. So, I wouldn't be surprised to see 10, 20% increases on your cyber renewals. And then the last comment I really had was regarding more of an increased use of artificial intelligence and analytics in the underwriting process, which I think is a really good thing. We're starting to see some creative insurance companies that are approaching cyber risk through data analytics and what we would call white hat hacking, an ability to look at your network for vulnerabilities and things that they can see from the outside, which really provides a much better gauge of sort of what the true risk is for compromise versus the old-fashioned way of filling out a 6-page application and getting a quote back. So I think as an association, you can probably look for some more innovative approaches to cyber risk in 2021 and the years ahead. So with that, we can turn to risk number 3, which is telecommuting and remote working. And while we put the poll question up again, from a risk management perspective, we've been aware for many years that a number of employees have been working remotely. Obviously, this exploded in 2020 with COVID, and it presents some unique challenges to associations. There's obviously the cyber risk component that we just talked about, where you have end users working from their home network, which is probably going to be quite a bit more vulnerable to exploitation than working in an office environment. And then in addition to cyber, we have to factor in issues like productivity, morale, workers' compensation, general liability, and so forth. So, folks are viewing this a little bit as a lower risk, Kellie.
Mm-hmm. That may be because teleworking and remote working, I think in the association world is something that's not completely new. So I'm hoping that means that the associations have taken a look at their programs and their policies and have everything in place. And what they were able to do was move that over to the COVID situation in 2020 and what may happen in the future. I suspect that there will be less people, that several people will not want to go back to the office anytime soon, even after vaccinations are rolled out. But as Derek said, the risks to employees, the risks to employers due to employee actions don't stop when employees work at home. You know, employers still owe a certain duty to their employees. Employees will still have injuries at home, and workers' comp claims will result. Employees probably will have a greater chance of creating a data breach at home. That may be because they want to use a home computer instead of a work computer that has appropriate security, technical security in it. Another thing that could arise is if an employee is working at home, it may be possible that the employee has confidential information for proprietary information belonging to the association on his or her desk, and maybe the desk happens to be the dining room table, and perhaps friends come over or visitors come over with masks, of course, and see that information. That's probably not a great risk, but something you should certainly address with your employees. The association needs to have an understanding with every employee as to the work hours. You know, are they required to now work 9 to 5, or can they work in the evenings and have part of the day free? This is a real concern for non-exempt employees because they need to be paid overtime legally. So you have to have a way of managing that time. One of the risks that may be new with telework is where the association should be paying state and local tax. An example, my formal office is in Washington, D.C., but I have been working in Maryland since mid-March. So the question is, where does Whiteford and Taylor and Preston pay taxes on my behalf? And I think that's, if you've had regular employees working at home or working in remotely, you've probably addressed that. But for this temporary, maybe temporary scenario, maybe you have not. One of the things I recommend is to have a formal telecommuting policy that every employee understands, and it would be nice if they would acknowledge receipt of it in some fashion. But the policy will discuss, what you require as far as safe working hours, safety features at home, who bears the risk of damaged equipment, etc. Derek, over to you.
Yeah, Kellie, thank you. I just have a few observations here. Again, workers' comp policies are going to cover employees automatically in the state that you're working in until the policy renews for another period. So you've got a little bit of a grace period where people will be picked up automatically if they happen to relocate to another state. But if they permanently move and are working in a new state, then you need to let your broker know so they can add that state, which of course opens up all of the issues that Kellie just mentioned around payroll taxes, or in places like New York or New Jersey, California, where you may have unemployment insurance issues or disability insurance requirements. There could be a host of new burdens on association employers. I think the overall risk, as the group rated it as low, I tend to agree with that. From a workers' comp perspective, it's pretty hard to, pinpoint exactly what somebody was doing if they got hurt, if they were, maybe carrying the laundry or taking care of the kids, or were they actually working. But, if something happens to somebody at home and you need to report it, you report it and you go from there. I think the cyber risk is probably a little bit higher, and again, would encourage the use of the VPN technology and all the latest cyber protocols. I think that's it on telecommuting. We can turn to risk number 4. Again, probably no surprise that this one will be on the list here. COVID, the COVID pandemic. So take a second to rate your risk concern there. I think like myself, maybe a lot of people were hopeful that in this first quarter or second quarter of 2021, we'd get kind of a better handle on the pandemic. With the vaccine deployment, we're seeing it take place in sort of fits and starts, and it's rolling out, but now we've got some new variants popping up in the UK and South Africa and Brazil making their way to the United States. So, you know, we're probably going to be in this a little bit longer into 2021, no doubt about it. And, you know, not to make light of it, but, you know, from where I'm sitting in terms of the vaccine, I kind of feel like a passenger on Southwest Airlines in the C boarding class, you know, like C45, and I'm sitting here waiting, and they're just still, you know, taking care of the pre-boards, and it's going to be a while. So. Kellie, over to you.
Okay. I just want to circle back to the comment that Derek made about the risk of teleworking versus cybersecurity. One of the very obvious things, reasons why cybersecurity is more important or more of a risk is because of the damages could be quite higher financially for the association. The damages could be very extreme if, for instance, there's a violation of GDPR that's not reported properly and quickly. Okay, COVID. We're all very familiar with personal risk created by COVID, and I think we all know at this point that an employer has an obligation to continue to protect the health and safety of its workers. A failure to do so could lead to multiple claims by the employee. What every association needs to continue to do is follow CDC guidelines and EEOC guidelines and federal and state and local requirements. If an association or employer continues to do that and has a back to work plan and ongoing work plan that satisfies those of CDC, EEOC, federal, state, and local regulations, the risk of a claim by an employee against the association is minimized. Unfortunately, there still is no federal legislation that bans claims based on COVID. From a federal perspective, many states do have them, but everyone needs to recognize that those statutes are never going to cover negligence if an employer is negligent. So you need to be on top of what the requirements are. And even though we'll be going back to work, hopefully sometime maybe in third or fourth quarter 2021, that plan still needs to be in place, because even when vaccinations ramp up, it's going to be a long time before COVID is something that happened to us long ago. One of the biggest issues, and I will say this is probably the new issue to all of you because it's just new, it has to do with vaccines. This is one of the most risky, probably not the riskiest area on our list. You've probably all considered whether you should make vaccinations in your workplace mandatory for your employees. That's a very complicated subject for a number of reasons, and I certainly can't get into all the reasons here, but when you get to this point, this is when you really need to speak to counsel, an employment lawyer who can guide you through this. Guidance came out in December of last year from the EEOC, which discusses vaccines. That guidance discusses when an employer may even ask an employee about whether it has had, he or she has had or has been in contact with somebody who's had COVID. And it addresses when and how an association can mandate vaccinations. There's two different tests here. One where if an association wants to mandate a vaccination, if it's done on premises or if the association hires a third party to provide the vaccination, there's some issues associated with that program. And there's different issues associated with if the mandate is employee, you need to come back with a some kind of card or acknowledgement that you've actually had a vaccination, either from your private doctor or for one of the state programs that are being run out. But you need to understand that there's EEOC guidance, which must be followed, and there could be multiple implications of the ADA, the Americans with Disabilities Act. If somebody refuses to have the vaccine because of an underlying issue or anything that may come within the confines of ADA, there are certain steps that have to be taken. Also, you have to be very careful not to violate the Genetic Information Act, which is referred to as GINA. So there's another issue that has recently come up. I mean, there's the issue for employers. Do you require the vaccine? You know, do you mandate the vaccine? Then there's the issue, if you do so, what happens if people either people say they're not going to take it from a religious perspective or from something that falls within ADA. There's another issue to address here, and that is what happens if the association says, I'm not going to mandate it, but then you have an employee who's been working at home and says, if you're not mandating it, I'm not coming back to the office. That's another area that will have to be handled delicately. So I do really encourage all of you, when you start thinking about these issues, to really speak with counsel. I will say that Whiteford, Taylor, and Preston recently had a very informative webinar, which is you can find on our website, which addressed all these issues in detail. Derek?
Yeah, good information. I'm going to dig into that myself. I've personally not had any liability-related claims due to COVID to date. I think it's a little bit hard to prove where somebody may have contracted the virus, but that said, we certainly have filed a number of business interruption claims, which we think likely will be rejected and not paid out on, but we're just doing that more as a precaution to keep its place in line in the event that there would be any state legislation down the line. And just, as a note of caution for everyone on the webinar, just take a look at your policies for any new exclusionary language that's being added. You may not be able to avoid it necessarily, because the insurance companies are certainly pushing for more restrictive language on liability policies to add, say, a communicable disease exclusion or a virus type exclusion. So just some things to keep an eye out on. We'll keep going here. On to risk number 5, events, meetings, and conventions. So, when we look back at 2020, obviously, one of the key lessons we learned from the year was the ability of associations to pivot quickly from in-person meetings to online virtual meetings. This is really a critical way to stay connected and engaged with your members. And in many cases, these were very successful. That said, introverts like myself even are looking forward to getting back to more face-to-face meetings at some point this year. And while I don't have a crystal ball, hoping it's by the 3rd or 4th quarter if things go well. So that said, I think your spring conferences and meetings, your decision making maybe is a little bit easier in terms of which way to go, perhaps. But if you have, say, late summer, fall, early winter meetings coming up in 2021, maybe some tougher choices to be made there. Again, this kind of wraps in cyber and contracts, so there's a lot going on here. Let's take a look at the results. High risk, definitely.
Mm-hmm. Okay, just get back on. As Derek suggested, the issue with COVID and meetings and conventions is not new to any of us. We'll continue to have those issues, from a legal perspective, from a damages perspective, loss of revenue perspective. Of course, we're still going to have issues with existing hotel agreements. The agreements you probably have in place now for 2021, they're already drafted, they're in place. It's not likely that the hotel is going to agree to amend the force majeure clause at this point, although they may be willing to amend the contract depending on local rules, state and local rules, as to how many people can congregate. That may still be an issue well until the end of the year. They may be willing to amend the contract in order to move the meeting. If you do that, however, I would also try to amend the force majeure clause at the same time. You may be, depending on where we are with COVID at the time and which the language in your contract currently says, you may be able to just say, I'm sorry, I'm terminating the meeting. I have no liability. I don't have to agree to you have this meeting another time to give you revenue. But if you're willing to do that, then you should be able to get something in return, which may be a better written force majeure clause. There are risks for the meetings when they start to occur again. Some of them are waivers. Waivers may not be enforceable. You should never ask an employee to sign a waiver because they have certain rights as employees. But if you ask your participants to sign a waiver, sometimes they're not enforceable and they should be carefully construed and carefully drafted in compliance with state law. One thing you need to think about is contracts for future events. I think there's going to be changes in the convention and hotel and meeting environment. I think it may be more difficult to get terms that are favorable to associations. I think the prices are also going to go up because I think hotels and convention centers lost a great deal of money, as we all know. And I think they're going to try to recoup some of that. So you have to be very careful about penalties and changing some of the terms. It's never a good time to just say, oh, we've done, business with hotel chain X in the future, and I'm sure they're going to give us, a great deal. You've really got to dig in when you're presented with new contracts. One of the issues there is from a financial perspective and risk is when you start budgeting for, let's say, 2022, and if I'm correct, if the environment for contracts for conventions changes, then you need to make sure you're budgeting appropriately for higher costs. Another reason that hotels may try to get more out of the associations is because they're probably going to have less meetings. I think associations have realized that it's easy in some circumstances, or it's not so difficult in some circumstances to have virtual meetings. There are issues. I think we've all gotten over or learned how to use Zoom and other types of virtual meeting platforms, but there's also increase in cyber issues, which Derek alluded to. So there are some issues. One thing I do want to point out, this has come up recently, actually in Washington, D.C., is many of you may have a bankruptcy clause in your contract with a hotel. Those clauses are generally unenforceable. A lot of people don't understand that. But if the venue that you are planning on using in the future files for bankruptcy, as I said, one of the largest hotels in Washington, D.C. recently did that, that doesn't mean that your contract is automatically terminated. Depending on the circumstances, often the debtor can claim that the contract is an asset. And then you can't do anything until the bankruptcy finishes or without the consent of the bankruptcy court. I'll just want to briefly touch on one other point, which is sexual harassment claims, or third-party claims, harassment claims. Every association should have a policy that's specifically written towards a meeting outside of the office. Let's say you're having a big convention. There should be a policy that every exhibitor and every attendee recognizes that says you won't put up with harassment and you have the ability to eject them from the meeting. And also there should be a contact person for individuals who think they are being harassed at the meeting, individual for them to contact about that issue. Derek?
Yeah, thanks, Kelly. Event cancellation insurance is still a really important risk tool for associations, but just beware this market's in some real turmoil at the moment. Obviously, there's not going to be the communicable disease coverage for COVID or any communicable disease for the foreseeable future. My colleague Patty Loftus actually is handling about 150 active claims from 2020, so it's a really busy time in that space. So the markets are really reeling from the amount of claim activity. We're seeing rates up about 30%. And, it's still an important coverage, like I said. There's some new products coming out that are addressing virtual events. A little bit hard to pinpoint the value at this point. They tend to be related to general internet outage scenarios, like we've been kind of having on the East Coast this week. But they typically will not cover cyber or, COVID. So we're still kind of testing the value of some of these newer coverages. And then the other observation I would make is just remembering that your cyber insurance program may have some value for you as it pertains to virtual events, especially if there's any sort of hacking or a way that you can demonstrate loss to the association from a breach of say an IT vendor that's hosting your event. So just keep that in mind, that cyber insurance can be a tool here as well. We're going to move on to risk number 6, and we're going to get through the next 5 in about the next 10 to 12 minutes, and then we've got some great questions in the chat that we're going to get to. Risk number 6 is employment practices. We've definitely seen a lot of pressure on associations during 2020 due to revenue and budgets, the financial uncertainty of COVID, obviously. Some associations have been able to hold the line in terms of their employees. Others have had to make some difficult job cuts or reductions in force. And coupled with that, obviously, we've got some pretty amazing and significant cultural phenomena going on with the Me Too movement, Black Lives Matter, and other sort of things just sort of in that employment-related realm. So this is putting a lot of pressure on associations. So let's take a look at the risk. Yeah, medium to low. Kellie?
Thank you, Derek. Employment practices and laws are constantly changing. So one of the most important things is to make sure you have someone within your organization that stays on top of the changes, because employee claims are very costly. And as Derek mentioned, there are a lot of cultural changes that have been happening in the past year and a half, 2 years, that employers really need to stay on top of. They impact hiring, terminations, hostile work environments, employees interacting with each other. So it's some new, even though I'm sure all of you are on top of employment practices and the laws, and such as vacation and what you have to do to terminate people, and ADA and other things. You just need to know that this is a different time than it was 2 or 3 years ago. Civility and inclusivity is a major topic now, and that needs to play into your employment practices. Training, again, not a new issue at all. Sexual harassment training has been ongoing for a long period of time, but training now should be extended to such things as Black Lives Matter and marginalization of women in the first workforce. One of the things that I want to point out, and I think this will be an issue that we may see some increased claims or concerns, is when people come back from COVID, maybe mental health issues, because I think COVID has impacted people in many ways, and some of them will be mental health issues, not only because of the individual, him or herself, but maybe with children being at home more than usual, or spouses losing their jobs. So I think that's something that employers need to look out for. Derek? I think we're on the next slide.
Sorry, Kellie, I was on mute and it took me a minute to get back here. So let's move on to directors and officers. This is, an evergreen topic, obviously, but it's also really important to add this to our list this year. So directors and officers are really faced in 2020, 2021 with some pretty significant decision-making responsibilities. There's a lot of liability around the management decisions that are being made for Ds and Os. So And it's really critical to work with your boards and make sure that the volunteer boards of directors have an understanding of what their duties and obligations are when they step into that role. Let's take a look at our results. Okay, so we've got some high there, some medium, and more on the low side.
Again, risks of directors and officers' actions is not new to any of you. And I'm sure most of you, or hopefully all of you, have some D&O coverage, but one thing that I found that really reduces this risk is a very careful nominating committee, or perhaps it's part of the governance committee that can really vet qualified directors. And not everybody knows how to be a director, doesn't maybe know what the 3 duties are that they're required to have to be a board member. Duty of care, duty of loyalty, duty of obedience. But a nominating committee, if they sit down and really look at the candidates, they should be able to select people and maybe have to call and twist their arms a little bit to join the board. They should have a working knowledge of the industry and really the willingness to commit to the position. Training is very important. I always suggest that if you have a very small association or a very large association, that there be some type of board training given to individuals before they join the board. D&O claims can be very costly. They not only from a financial perspective, but if you look at some of the claims that have occurred with, let's say, the NRA recently because of board actions, have not helped them from a reputational standpoint. Derek?
Yep, thank you, Kelly. I think on D&O, just like employment practices, there's not a whole lot new in terms of the coverage forms from an insurance perspective, but probably the biggest message to relay to all of you today is just expecting some pretty significant rate increases along these lines, probably in the 10 to 20% range. So you just need to be aware of that. This will especially be true if you've had any layoffs or past claim activity. And the other area that we have seen a little bit more uptick in activity is around antitrust claims. So just being kind of on top of what your D&O and your E&O policies say with respect to antitrust coverage is pretty important. We're going to move on to risk number 8, external risk, geopolitical risks. Well, Kelly, it was my big idea to add this one to the list.
It was.
But I think this past year, the past few years, definitely the past few weeks show us how quickly events can spiral out of control. And I've been pretty intrigued even to watch this week kind of this Reddit, the day traders going after the distressed stocks of GameStop and these others. It's been interesting. It's not germane to associations necessarily, but external risks can definitely can spiral into the association world pretty quickly. Just coupled with that, we've seen some civil unrest. We've got COVID and pandemic. We've got the spread of misinformation. So there's a lot going on externally that we need to keep an eye on.
Right. Some of the risks are also that external risks that could impact an association are member bankruptcy. How do you deal with that if a member is bankrupt? Can you if they haven't paid, let's say, their 4th installment of dues, can you terminate their membership? Foreign members and financial crisis, those are some of the issues you have to anticipate. One of the ones that I think is really risky is when you have employees or maybe even volunteers traveling to countries that are in turmoil. For instance, there's in some areas of the world, there's kidnapping for ransom, especially if they know that there's an employer who's probably going to pay. So these are real risks that often aren't anticipated. The consequences of these actions aren't anticipated, and you really need to do so. Derek, back to you.
Yeah, so I think building a good team around you is critical in these times. Your legal team is important, obviously, accounting, insurance, et cetera. What I would just add to this is we work with some really interesting firms on the international space that Kelly was alluding to, like International SOS. is just an example to throw a name out there. But it's a group that's really familiar with repatriation and managing travel risk, but they've kind of pivoted into sort of this COVID consultancy as well. There's some really interesting things going on in that area, and I would just really advise associations to make sure that you're plugged into partners that are really helping you advise in these areas. We are going to turn to risk number 9, and I know, Kelly, this is one near and dear to your heart. We all get these funny memes and cartoons that splash across our screen. I got one just last week. Somebody sent across this little cartoon that said, "Awesome Possum." And right underneath it, you could see the little copyright designation, and my head nearly exploded. So I know that IP is a big concern. And certainly in this age of artificial intelligence, the people out there who are keeping an eye on your use of IP is certainly growing as well.
So we're waiting for the poll. Yes. Okay. Media risk. Okay. Well, this is an area that's ripe for claims by third parties. Artificial intelligence is actually correct. There are bots that can sweep through the internet to find photographs that have been used that are on slide decks, such as the one we have for you here. You'll notice there are no cartoons or no photographs, because what these bots do is actually find them. And then all of a sudden the association gets a claim letter from the copyright holder. This has happened to several of my clients. One of the ways to actually try to alleviate any risk associated with speakers at your conferences is to have speaker agreements. And they need to warrant that they're not going to use any visuals that are owned by someone else, and if they do, you also should have an indemnification clause there. You should make sure that the agreement says that participating in the conference is within the scope of that individual's employment, if that is the case, so that the employer can provide indemnification. These clauses or these claims are not winnable. If there is a cartoon that's used inappropriately by a speaker at your conference and his or her slide deck ends up on your webinar, you have probably violated the Copyright Act. Another thing is one of your most valuable assets is actually your own intellectual property, whether that's your logos or proprietary information you own. You should never let anyone use a logo without some type of understanding of how they can use it. And as I addressed earlier in the program, ownership of IP that's developed by a vendor. If you paid for a deliverable, if you paid a vendor to produce something for you, you should own that, and that should be covered in the contract. Derek?
Yeah, thank you. Intellectual property is covered by various insurance pieces of your portfolio, just as a reminder. You're going to see some coverage both in your general liability, probably in your directors and officers policy, definitely in your media and cyber policies as well. So it's kind of a patchwork of coverage there, but you got to make sure that all of that comes into play and works together. So, a big piece of the IP coverage is really how active your association is in the media space, how big your footprint is. So we're going to move on to our 10th and final risk, which I take ownership of, which is insurance. How do you feel if your association has adequate insurance to cover your risks? That is the question. What we are trying to advise clients this year is really to avoid surprises by preparing, and in particular, preparing for a hard insurance market. We're really in a tight market at the moment. I'm going to show you a couple of slides here, but it's definitely impacting medium to larger associations in particular. Let's take a look at the poll results. Yeah. Okay, that's good. There's a lot of yes and some unsure. So let's look at the slides that'll give us a few minutes for Q&A. And I'm going to cover this in about 1 minute, Kelly. So you've got about 4 minutes for Q&A.
Okay.
So we can go to the next slide, please. So just really quickly, this is about a 20-year snapshot. If you look at the graph on the bottom left, That's when I actually entered the insurance industry about 2001, and we were at about a 30% increase that year. So I jumped in to the market right at the highest point in the past 20 years and got exposed to delivering 30% renewals. And over 20 years, it's hard to remember that period, but we're almost trending back into it in the last 3 or 4 quarters. You see now that we're up in that 10 to 15% range. Directors and officers on the right, double digits, somewhere in the 16% increase for Q3 2020. Next slide, please. And just a couple of lines. Umbrella coverage getting hit pretty hard, 22.9% increases. Commercial property up 14%. This is not to scare you, it's just to let you know that the market is difficult right now. You need to know that when you're budgeting, and you need to have conversations early in the renewal process to understand what's going to happen to your program to achieve the best outcome. Okay, so that's it on the market. I think we can go to Q&A, Kellie.
Okay, I think I can, since we only have a couple minutes here, I think I can probably run through most of these, Derek, if that's okay.
Beautiful.
The first one is about automatic renewals. Automatic renewals are fine if you have control of automatic renewals. The best way to have an automatic renewal, and I do understand that if an agreement just terminates, then maybe you have to renegotiate and the prices are going to go up and the terms are going to change. But it's best to have an automatic renewal if you want one, if you need one, that says you, the association, have the right to say no to that, not the other party. So the contract automatically renews unless the association gives notice of its desire to terminate. So that gives you control. So that is really the best way to use an automatic termination. But then you need to have somebody who stays on top of those dates, because more often than not, or not often, somebody forgets that you wanted to terminate and you didn't send the required notice, and then the other party says, well, I'm sorry, you didn't give me timely notice, so we're signed up for another year. Second part of that, if the contract has expired by your terms, is it still being performed, enforceability, the written contract's terms? That's called performance. So if the parties are still acting as if the contract is ongoing, generally speaking, you're performing under the terms. But that doesn't mean that if it's terminated, that the vendor can say, okay, I'm done in 60 days. So you really want to be careful that doesn't happen. Next one, you're responsible if there's a breach to notify your members and others. Absolutely, no question about that. But that's why it's so important for the vendor to notify you, so that you can make timely notification to not only your members and others. Maybe you have exhibitors who aren't members, you have some of their information, especially if you have their credit card information. Hopefully you don't keep any of that. But also there are notifications that must be made to the EU countries if you have any foreign data. So that is your obligation. Let me see. No, you may not ask an employee to sign a waiver of claims. You have rights, employees have certain rights, and you can't ask them to waive them. The best way to not have an employee claim, at least within the office, is to make sure you follow EEOC guidelines, state, local, and federal guidelines as to protecting the employees. Yeah, so unfortunately, that's not going to help you at all to ask them to waive. One thing you'll need to consider is if an employee says to you, well, you want me to travel to XYZ and I'm not going to do that. And as I mentioned earlier, there are some considerations there from a legal perspective, and you should really discuss that with counsel, because you shouldn't automatically say, okay, then I'm going to terminate you. You should consider how you're going to accommodate that person's issues, especially if the person has disability and can't have the vaccine, or for a religious reason won't take the vaccine. There may be an accommodation for this person until COVID is well behind us. So
Thank you, Kellie. I know you have to drop. It's the top of the hour. If you want to say any final words, feel free to drop if you need to.
Okay. Thank you, everyone. I hope this was helpful. Again, these are top 10, and hopefully you will just take some time to consider how these fit within your program and your risk program. And if you have any questions, our information is below, and please reach out to us. Thank you. Enjoy the rest of the afternoon. Thanks, Derek.
Thanks, Kelly. Thanks, Derek. And thank you everyone for attending today's webinar, Looking Ahead, Top 10 Legal Risks and Management Solutions for Associations in 2021. On behalf of Whiteford, Taylor, and Preston and AHT Insurance, thank you for joining us today, and stay well.
Thank you.